Okay, good afternoon, everybody, and welcome. My name is Matt Waters. I'm an attorney at Jordan Price Law Firm in Raleigh. I'm currently the chair of the North Carolina Bar Association Real Property Section and also co-chair of the Return to the Vault Committee, along with my co-host today, Kyle Smalling with Capital City Law. Kyle, do you want to unmute yourself and introduce yourself?
Sure. I'm happy to be here today. Again, Kyle Smalling with Capital City Law. I think maybe me and a lot of other participants on this call are very interested to hear what David has to say. With everything going on, this is kind of falling on the back burner for me in terms of keeping aware of what's going on. And I'm very excited and very much know I'm going to learn a lot today. Thank you, David.
Thanks, Kyle. We're very glad to have you all with us here today for such an important topic and program. And I want to extend a special welcome to those of you that are here, our friends and colleagues from other sections of the North Carolina Bar Association. So if you're here with us today as a member of a section other than the real property section, please feel free to say hello and let us know what section you're here joining us from. You can use the chat box to do that, and I hope all of you here in this program today will feel free to use the chat box to make comments, say hello, and let us know where you're joining us from for this program. As Kyle said, we're very glad to have David McCallum here with us today to present a program on the CCA, Beneficial Ownership Information Reports and Implications to Real Estate Practitioners. David represents clients, individuals, fiduciaries, partnerships, corporations, and other entities in tax controversy matters before the IRS, including the appeals office, and in litigation before the tax court. His clients range across industries, including technology, construction, manufacturing, health and life sciences, government contractors, financial services, and professional services. David also helps clients navigate and comply with complex tax and business laws and regulations and subsequent tax controversies. So David, glad to have you here with us to present this program. Just a little bit about Return to the Vault program. If you're new to this program, this was the program that we created in 2022 with the North Carolina Bar Association Real Property Section. It's a way that we found was a good thing for us to be able to use to reconnect, re-engage, and re-energize our section and membership, particularly as we emerged out of the COVID-19 pandemic and everything sort of moved to this virtual world that we find ourselves in. These programs are monthly 1-hour programs on the second Wednesday of each month at noon. These programs are all recorded, as you saw that notice that popped up on your screen, and saved as content for our section members. So members of our real property section have access to both the presentation and slides and materials. And any of you here today that are joining us from other sections, and if you wish to have these program materials after this, feel free to reach out to me or to Sherrard Johnson, our community manager at the NCBA, and we can be sure to get you a recording and also the program materials. This program, though, is not offered for CLE credit. All right, quick programming announcement. Our next Return to the Vault program, November 8th at noon. We will have a legislative update presented by Nancy Ferguson with Chicago Title, and that program will also be sponsored by Chicago Title. If any of you here have any ideas for future programs or content, if you want to be a presenter or if you want to be a sponsor of a future program, please feel free to email me or Kyle Smalling. You see our email addresses there on your screen. Also want to extend a very warm welcome to our sponsor for today. We have Town Bank with us with Sarah Boschert. She is a Senior Vice President and Private Banking Officer with Town Bank. Please stay tuned to the end of today's program to hear a message from Sarah. And also there will be 10 lucky winners that will be drawn during today's program from the list of attendees. And those 10 winners will each receive a $50 gift card courtesy of Town Bank. So with that, I'm going to turn things over now to David McCallum, our speaker. David, I'm going to stop sharing my screen, and that should give you the ability to share yours. And if not, we can be sure to give you that capability.
There we go.
There. All right. Thanks.
Mm-hmm. Okay. So while you're perusing the just a little bit about myself, like Matt said, I am a U.S. attorney. How I got into this topic in particular was not being able to keep my mouth. I'm sorry, can everybody hear me? Looks like
Yes,
Zoom.
yeah.
All right, do I need to share my screen again? Okay. Are we back in business now? Okay. So I got in Corporate Transparency Act because I was unable to at a corporate and tax practice group meeting.
Excuse me.
David, if it helps you, I can share my screen if it helps you, and you can just let me know when to advance the slide. David, did we lose you again? Sorry, everybody, for the technical difficulties. I think we may have lost David again. Okay, if you have any more issues with sharing your slides, I can share them on my end, and you can just let me know when to advance. Otherwise, take it away.
Yeah. Why don't we do that? Because I'm getting another Zoom quit unexpectedly message. Let me stop. All right, so hopefully everybody's had plenty of time to look at the agenda now. So Matt, if you want to go ahead and move to the next one. Okay, so the Corporate Transparency Act has an effective date of January 1st, 2024, particularly for entities that are formed after that date. But it was enacted as part of the National Defense Authorization Act of 2021, right at January 1st, 2021. And it's under the scope of the Anti-Money Laundering Act of 2020. And basically the statutory schematic just provides a framework that Congress then gave a bunch of authority and discretion to the Department of Treasury, more specifically the Financial Crimes Enforcement Network, FinCEN, to craft regulations that are going to flesh out the details, establish definitions, set deadlines, and all of that stuff. But the main goal of the Corporate Transparency Act really is to allow law enforcement agencies, other regulatory agencies, to kind of cut through multi-layer ownership where you've got various entities or other trusts involved, and really find out who is the ultimate individual economic beneficial owner of this kind of entity chain or these various entities. So it's really a anti-money laundering effort and an anti-terrorism effort is the main purpose of the statute and the schematic. So all the Corporate Transparency Act does, other than a few definitions, actual statutory language, is tell FinCEN and Treasury that they need to establish beneficial ownership information, BOI or BOI, if you will, reporting requirements for entities that are active in the U.S., including foreign entities that are operating in the United States. And then for FinCEN to create a database to store all this information that's going to be reported, and it needs to be secured. Matt, you can move on to the next one. And so here's the kind of current status of the guidance and the rules that we have right now. So we have final regulations on the beneficial ownership information reporting, which is the bulk of what I'm going to talk about today. Those have been final since September of 2022. We've got proposed regs on BOSS. BOSS is the database. That's what they refer to it in the initial proposed regs. A lot of the guidance that's come out later, they haven't quite stuck to that acronym. We'll see what it ultimately ends up being, but I thought BOSS was a pretty good acronym in terms of government acronyms, so we'll stick with it. Second thing was, FinCEN is required to let U.S. citizens know when they're going to establish a new reporting system. And so there we see the notice that was issued a couple of weeks ago, saying that they've created a new database that they're going to be monitoring and administering related to these beneficial ownership information disclosures. We have some additional proposed regs that came out at the end of September on the beneficial ownership reporting, which essentially is more of a transitory rule. Comments are due at the end of October. I don't see this reg not becoming final or, making an amendment to the final regs. And it is essentially just saying for entities created after January 1st, 2024, but before January 1st, 2025, that they will get 30 days to file those initial reports. I mean, they'll get 90 days to file those initial reports instead of the 30 days that are currently in the regulations. And finally, the other things that are out are the actual proposed report or form itself. The most recent one was 929 a couple weeks ago, and that is the second iteration of the draft form. And there also is a FinCEN identification number application draft form out there as well. So kind of the outstanding items, which are significant considering we only got 2.5 months left before this is supposed to become effective, is the final regulations on the database, who can access it, how they can access it, what sort of penalties or protections are in place if there's unauthorized access. And of course, the final forms and reports for the beneficial ownership information. And finally, there are proposed and final regs that need to come out that are going to harmonize the Corporate Transparency Act and the customer due diligence rules or know your client rules. Those, per the statute, can be finished within a year after the effective date. So those are supposedly supposed to be done by 1/1/2025. Matt, if you can go on the next slide, please. Okay, so what is this reporting company requirement? What is a reporting company? Who has to file this information with FinCEN? Okay, so the Corporate Transparency Act requires reporting companies to file personally identifiable information of the beneficial owners of a reporting company with FinCEN. And so again, we are getting down to the individual level here. This is not like entity reporting. You're not going to report that, our reporting company is owned by this LLC. We're going to the beneficial individual owner level, who's the ultimate economic beneficiary here. And so what is a reporting company? It is a corporation, a limited liability company, or any other entity really that has to file formation documents with the Secretary of State, or whatever your state's equivalent is of Secretary of State. For us, it is just the Secretary of State. And so, that's a broad brush right there for a reporting company off the bat. Very broad definition for a reporting company. And, the regulations pretty much don't give any details on what an other similar entity is, other than saying that it is created by filing a document with the Secretary of State or similar office. Or if it's a foreign company, it registers with the Secretary of State or equivalent office. No real deep dive in there. Matt, can you move on to the next one? And so aside from corporations and limited liability companies are specifically stated, this is going to cover limited partnerships, limited liability, limited partnerships, all down the line. So what's out? General partnerships, because a lot of states, most states, do not have, or not usually don't have to file something with Secretary of State. Trusts that are not statutory trusts, you usually do not have to file some sort of formation document. And I do want to stress that, it is a formation document. I don't think an assumed name certificate is going to trigger that reporting requirement if you were a general partnership. and you file a assumed name certificate with the Secretary of State or whatever entity, I don't think that's going to trigger a reporting company obligation. And so I have down here open issue. What about a foreign company that just owns some real estate in the United States? And, based on that state's laws, they don't have to register or apply to do business or apply for a certificate of authority or anything. I think that is not going to be a reporting company based on the guidance or some of the guidance and FAQs that have come out lately. Matt, if you go to the next slide. There we go. So this is a flow chart ripped directly from the small entity compliance guide, and it's also in the FAQs on FinCEN's website for this beneficial ownership information. And this is kind of your flow chart to, are you a reporting company or might you be a reporting company? And, corporation, LLC, no, then were you created by filing some sort of document with DEF? Was a creation determined by filing some sort of document with Secretary of State? Then you may be a reporting company unless an exemption applies. Foreign's over here on your right side. Again, so if you're a foreign company and you don't have to file anything, then I would say you're not a reporting company. So that issue has, seems to have been resolved by these recently released FAQs and the small entity compliance guide. So hopefully that provides a little bit more clarity. But this is a kind of analysis you're going to have to go through if you're helping your clients form entities, or if they ask you about it, that this is one of your initial decision trees or flow charts you're going to have to go through. Matt, can we move on? Okay, so we have a really broad definition of reporting company. And then we have 23 specifically listed statutory exemptions from the definition of a reporting company. The idea behind most of these exemptions, according to the legislative history, is that many of these entities in these industries are already heavily regulated by other federal agencies or state agencies, rarely engage in money laundering or terrorism. Now, when the statute came out and the first proposed regs came out in beneficial ownership reporting, there were a lot of comments on, can these be a regulatory exemption? Can we add these to the regs as exemption? And the regs have 0 additional exemptions in them at this point. They reserve an exception for national security purposes. So if Department of Treasury and Department of Justice or the FBI or some other agency agree in writing that certain types of entities should be exempt, then there is the possibility for a national security exemption. So far, none of that has not occurred yet. So again, we've got banks, bank type entities, broker dealers, all very heavily regulated, FINRA, all those regulatory authorities. We got 501c3s, your nonprofits. I'm thinking that's because they rarely engage in money laundering and they do have a decent amount of regulation for considering what they're doing. Registered investment companies, public accounting firms. Apparently the accounting firms had better lobbyists than we did on this one, because if you will notice, law firms are not on this list of exemptions. And I think the 2 biggest exemptions that I think are going to apply, or most people are going to try to fall in, are large operating companies and subsidiaries of exempt entities. So basically, large operating companies, you got to hit all 3 prongs. So you got to be an entity that's U.S. person. So foreign entities cannot be large operating companies. You got to employ more than 20 full-time employees. The regs kind of dictate what the math is on a full-time employee. And you have to file income tax returns in the prior year showing more than $5 million of gross receipts. So, the way this definition, and have a physical office in the United States. So the way this definition works, you cannot be a large operating company in year 1, period. Because you're not going to be able to show $5 million of gross receipts in the prior year. So the first time you can meet this exemption is year 2, if you were formed after 1/1/2024. If you were formed before 1/1/2024, then you can meet this exemption because you're going to have that year and file tax returns to show more than $5 million of gross receipts. And then we've got the subsidiary of an exempt entity. So pretty much if you hit any one of the other 22 exemptions, a couple of them are carved out. So I want to say it's like 19 of the other exemptions. If you're owned by an entity that's any one of the other exempt entities, owned or controlled, then you can be an exempt entity as well. So I think you'll see some structuring using that exemption to maybe try to avoid some of these reporting requirements. Matt, can you move to the next one? All right, our first pure real estate focused slide here. I want to give a hat tip to Jim Slaughter at Law Firm Carolinas for suggesting I cover this topic as it relates to homeowners associations or community associations. Also, Matt sent me some stuff, but Jim sent me some stuff first, so we'll give him some credit there. So if you have an HOA or some other community association that's organized under 501c4 or 501c7, then you're going to be exempt from the CTA reporting requirements. But it's my understanding that most HOAs are organized under 528 because it's easier, right? You hit some statutorily laid out factors and then file the right tax return, and you're a 528. Whereas with the 501c entities, you've got to file an application with the IRS and get it approved. So most community associations are practically tax exempt under 528, even though not technically tax exempt. But the 528 organizations are not specifically listed on the 23 exemptions. And as I said, there are no regulatory exemptions at this point. So 528 HOAs or community associations are going to be subject to this reporting requirement unless another exemption applies. I'm not really seeing a lot of availability for them to be, to fall under any of the other exemptions. So, if you are advising community associations, HOAs, you're probably, want to inform them of this new reporting requirement, but also probably help them put policies in place on how to identify the beneficial owners that they're going to have to report and the types of personally identifiable information they're going to have to collect, and, policies on when this information is going to need to be updated if board membership changes or if management company changes potentially. And we'll get into some of this stuff a little bit later if you're utilizing a management company. But, again, broad impact based on the definition of reporting company and then just the 23 specific exemptions. So while the Corporate Transparency Act is focused on anti-money laundering and anti-terrorism aspects, the broadness of the definition of reporting company is going to capture a lot of entities, particularly smaller entities, that really, aren't the focus of the regime in the first place. Matt, can we go on the next one? Also, what about special purpose entities? A lot of them are likely to be reporting companies, and it's probably the same thing for them, going to be hard to satisfy any of the exemptions. Got a little scenario for you there, but lenders or financial institutions are going to want that property to be owned by a special purpose entity, and they don't want that special purpose entity to have any employees so they can avoid payroll tax, or workers' comp or other similar liens. But since that real estate's put in a special purpose entity, and that SPE is likely going to have an additional reporting obligation unless it can satisfy the large company operating exemption as a subsidiary, really, or subsidiary in exemption, because you can't get the large operating company if you don't have any employees ever, because you got to have 20 or more. And you could be throwing off $5 million of gross receipts because the SPE could own some really nice office complex or shopping center, but if you don't ever have any employees in the entity, you can't meet the exemption. So you're going to have to hope that your owners exempt. Again, I do think particularly the owners of a bunch of SPIs, of a bunch of real estate investments, might be reporting personally identifiable information on multiple occasions every year to FinCEN. And if that's the case, like if the ultimate owner entity of the SPI cannot satisfy one of the exemptions, then, I would recommend that the beneficial owners of those entities get FinCEN identification numbers, so they're not having to disclose their social security number in multiple filings, even though it's supposed to be a secured system. That just doesn't seem like a good idea to me. So again, one possibility here as well is, even if the way the ownership structure of the SPI is set up, or the entity that owns the SPI is set up, they might be exempt, or one of the owners might be exempt. So you might not have to disclose all the beneficial owners if the SPI is owned by multiple people. And we'll get into a more specific example in a second. Matt, can you move on to the next one? Okay, so we've talked about this beneficial owner concept a little bit, but let's get into definitions. Again, I do want to stress, we're really trying to get down to the individual level here. Who's the ultimate economic beneficiary at the individual level is kind of the goal for these disclosures. Directly or indirect ownership, through any sort of contract or arrangement. And you've really got two prongs you're looking at. They either exercise substantial control over the entity, or they own or control not less than 25% of the entity. And substantial control is broken down into, 4 more components. We've got our kind of your officer component. That's kind of your like de jure authority prong, right? Like, it's just assumed that these officers are going to have that requisite authority to exercise substantial control. Your second prong is kind of your de facto authority, your appointment and removal authority of board of directors or managers. And then same thing with the third one. That's also kind of de facto authority. Are you a decision maker? Are you really controlling? And then there is a catch-all category that substantial control can take additional forms not specifically listed. And that piece has gotten a lot of feedback from commenters on the regs, but so far FinCEN has not backed off on this requirement. FinCEN is, said that this, is kind of our common law piece, and that, in terms of the broader objectives of this legislation, that, we want the ability to be able to capture the people who are ultimately in control, even if they're hiding behind lesser titles or nominees or something like that. So with the catch-all provision, I think that we're going to lead to confusion and probably some over-reporting of beneficial owners initially. And I imagine there's going to be future guidance that eventually kind of fleshes this out a little bit. But in terms of, I just think it's going to be a lot of confusion here with the catch-all piece. There hasn't been a super clear definition. So substantially control piece, the catch-all piece is going to be, I think, the trip-up part. But Matt, can we move on to the next one, talk about ownership interest? Okay, so ownership interest is also very wide and broad ranging. Capital or profits interest in a partnership. Convertible instruments can be ownership interests. Debt instruments, if they enable the holder to exercise the same right as one of the equity members or capital or profits interest members. And again, we're also looking at this direct and indirect concept, and you need to aggregate kind of all the ownership interests to see if you hit that 25% threshold. There are some examples in the small entity compliance guide and in the FAQs and in the final regs that address some of this. And we've actually got an example on the next slide to kind of illustrate this as well. Matt, if you want to move on. Okay, so this is ripped directly from the Small Entity Compliance Guide and FAQs. All right, so we've got our reporting company there. It's an LLC. It issues membership units. We've got individual C is just a manager. Individual A is also a manager and he owns 50%, and individual B owns 50%. All right, in this scenario, on these facts, according to FinCEN, all three individuals, A, B, and C, are owners or beneficial owners of the reporting company. Okay, so A exercises substantial control over the LLC because he makes important decisions in his role as a manager. A is also a beneficial owner because he owns more than 25% of the LLC directly. He owns 50%. Now, I will say so you've made this decision, A is an individual owner. When you're filing the FinCEN report to disclose that A is a beneficial owner of reporting company, you're not going to have to specify how or why he's beneficial. You're not going to say like A is a beneficial owner based on substantial control, or A is a beneficial owner based on more than 25% ownership, or A is a beneficial owner based on both. You're not going to have to specify that. You're just going to have to say that he's a beneficial owner and then disclose the information, the personally identifiable information that FinCEN wants. Okay. B is a beneficial owner because he owns more than 25% of the reporting company directly. And C is a beneficial owner based on substantial control because C is a manager of the reporting company and he's a decision maker, and he's still a beneficial owner because he exercises substantial control. Now there is an example in the Small Business Compliance Guide that we can just throw off here. So let's say that B, instead of individual B owning 50%, we've got entity B that's an LLC that owns 50% of the membership interest, and entity B is then owned 50% by individual B and 50% by individual D, who's not on here. If entity B is a large operating company, exempt from the reporting requirements, then our reporting period, or what we need to report to FinCEN, is going to change. And so we would have to report individual A as a beneficial owner and individual C as a beneficial owner. But individual B, even though he still owns 25% of the reporting company directly through entity B, does not have to be disclosed because entity B is exempt. All you have to do is name entity B as an exempt entity on the form, and you don't have to disclose entity B's ownership. I think the same principle is going to apply if instead of individual A and individual B, we have individual A, we have non-statutory trust B owns the other 50%, and individual C is a manager. In that case, I don't think we have to report non-statutory trust B, because non-statutory trust B is exempt from, they are not considered, they don't meet the definition of a reporting company, period. Now, you may have to disclose the name. This is not entirely clear from the regs at this point. You may have to disclose the trust name, but you're not going to have to disclose the beneficiaries of the trust or the grantor of the trust, whoever the ultimate individuals who are benefiting from the trust are in the reporting requirement. Okay, Matt, can we move on to the next one? All right, so back to our kind of HOA community association discussion. All right, so again here, HOAs, community associations, are typically governed by a board of directors. Depending on the board setup, I would say they're probably going to be considered decision makers in a lot of these instances. I'm sure we come up with scenarios where maybe some of the board members are not, if they don't have enough power, but I would say a lot of times they're going to be decision makers in a community association. Thus, they're going to be beneficial owners of the community association, and their personally identifiable information is going to need to be reported to FinCEN. If the HOA has officers, the senior officers are also going to be beneficial owners. And depending on the authority of the officers versus the board, there may be some judgment calls that are made on to who's a beneficial owner or not. But let's say the HOA is managed by an external management company, and depending on the contract, the management company may be beneficial owner. I left this language in here, and it's really not that the management company would be a beneficial owner. It's that the owners of the management company, the individuals who own or ultimately own the management company may be beneficial owners of the HOA as well. I would say in most instances, the management company is not going to, rise to the level of having enough control where we're going to have to look through it to its owners. But if the contract doesn't provide for independent decision making by the management company, probably not going to get there. But it is something to keep in mind, because I can also see a scenario where the management company, if they exercise enough control, they're exempt, could they exempt the whole HOA? I don't think we really get there. I think we'd get to that scenario where you have to report the name of the management company and they're an exempt entity, but you still have to report the board of directors as beneficial owners. You just don't have to report the owners of the management company. Again, and in terms of, I don't think the lot owners, if the other members of the HOA or the community association, I don't think that they are going to rise to the level of beneficial owner here. I don't think they're going to have enough decision making process or to be a decision maker. But again, you guys might know this better than me. Is being able to elect the board enough power to exercise substantial control? I don't think that's what the intent of this is. And obviously, nobody's going to own more than 25% of the HOA, right? Of the community association. But I don't think the mere power to elect the board is going to rise to the level of substantial control. But I do think that's something that you guys might want to consider in your individual practices. But that may be a problem. Whereas if a developer still owns more than 25% or controls the HOA, then the developer maybe, or we have to look through the developer to see if you need to report the owners of the developer as beneficial owners of the community association. I think that is a definite possibility. There's also probably a pretty good possibility that the developer itself is a large operating company, depending on how long it's been around. And thus, you may have to disclose the developer as an exempt entity on the filing, but not go to that next level of who are the beneficial owners of the developer. Matt, I think I've addressed all the comments on that one. They were coming in pretty quick there, but let's move on. Yeah. Okay, so a little bit more in depth on property managers and or lenders and creditors as being beneficial owners. Can they fall under the catch-all? I mean, property managers are making decisions that influence the operation of property, but they're hired by and report to owners of the property. The final regs have a comment in there that I've kind of paraphrased right there. Day-to-day managerial decisions should not in isolation cause the decision maker to be construed as in substantial control unless another element of the substantial control criteria is satisfied. So if the property manager also happens to be an officer or something like that, or have the ability to remove board members or something like that, or can they exert negative control on the board? Maybe. But just being a property manager in isolation should not rise to the level of being a beneficial owner, where if the individual property manager is an individual, if the property manager is an individual, then he has to report it. I don't think we're going to get there. Or do we need to look through to see who the owners of the property manager are? I think in most scenarios, they are not going to be to exert substantial control and thus be deemed beneficial owners, or where we have to look through the property management company to see who the beneficial owners are. With creditors and lenders, again, it's possible, particularly with convertible debt, that they could ultimately be a beneficial owner. Now, I do think a lot of lenders and creditors are probably going to satisfy the large operating exemption, or just the banking exemptions that are in the 23 exemptions. So then you would just have to report the entity name or the lender name as a beneficial owner and not look through. But again, I think that, unless the debt's converted and has been converted and the lender's basically acting like an owner, they're not going to fall under this threshold most of the time. But it's when they can and start exercising the same rights as actual owners is when I think that issue really comes into play. All right, Matt, can we move on to the next one? Okay, so here's our beneficial owner exceptions. Minors are accepted, but only if the parent or guardian information is reported in their stead as beneficial owner. Nominees are exempted, but again, only if you report who the ultimate beneficiary is, who's utilizing that nominee. That person needs to be reported for the nominee to be accepted. Employees are accepted out. If you have a future interest in something via inheritance and you haven't actually, inherited that right is still a future interest, then you're accepted out. And creditors, unless they hit some of those substantial control requirements we just discussed. All right, Matt, can we move on to the next one? All right. So switching gears here, the other party that gets reported on these FinCEN forms, so you figured out who the beneficial owners are, and you've got those guys locked up in the form. The other one is an applicant, and the applicant is the individual, again, going down to the individual level, that files an application to form a reporting company. Form a corporation, LLC, or any other entity that requires formation filing with the Secretary of State or register as a foreign entity. And it's further broken down into, the person who directly files the formation filing. So I imagine for a lot of you, that's going to be your paralegals or your assistants, and the person who's primarily responsible for directing or controlling such filing. And that would be you as the attorney. And so, it could be the applicant could be an employee of a business formation service or a law firm, or associate or agent. And the examples in the regs and the final regs specifically, have a law firm example, and that if the paralegal files the articles of incorporation, they're an applicant, and whoever the attorney who is controlling the process is an applicant as well. And FinCEN's rationalization for this is that they believe the information about their person directly or directing or controlling the formation, filing, or registration of reporting companies could be highly useful to law enforcement, as they may be able to draw connections between and among seemingly unrelated reporting companies and beneficial owners. Now, this has gotten a little bit of criticism from other members of our bar that we are being used as gatekeepers, and it's pretty much what it looks like to me as well, but we'll see how this ultimately plays out. Matt, can we go to the next slide? Here's basically what I said in the prior slide in flowchart format. One critical point I do want to make is that applicants for entities that were formed before 1/1/24 do not have to be disclosed. I don't know if any of you guys were at the presentation I did about a year ago to the property tax bar. I don't know if it's your hot topic CLE or your deep dive CLE. This was not carved out of the final regs yet. you still had to report applicants for entities that were formed prior to 1/1/24. And I had like some crazy example of a company that was formed 20 years ago, and the applicant's no longer with the firm. He's been MIA for 10 years. Nobody knows where he is. Like, how do you make that disclosure, and what are the consequences if you don't? So thankfully, in the final regs, applicants do not need to be disclosed for companies that were pre-existing 1/1/2024. So, created on or after 1/1/2024, no, do not need to identify the applicants on the form. Created after 1/1/24, you need to. Was anybody supervising the process or involved in the process beside the person who directly filed it? Then that individual is controlling the process, needs to be disclosed. So for companies that are formed after 1/1/2024, there's going to be at least one applicant and maybe two. Okay. Matt, can we move on to the next one? Okay, so here's the information that needs to be reported. Full legal name, date of birth. This is for the beneficial owners and the applicants. There is a little bit of carve out for applicants. If you're an applicant and you are doing this on behalf of, your law firm or whatever, you just need to disclose the street address of the firm or the entity that you work for, not your personal address. If you're an applicant in your individual capacity, or you're that, then not through a business, then you need to disclose the residential address. And then a unique ID number. That unique ID number is either a valid passport ID number, driver's license, or other state issued ID number, foreign passport ID number, one of those four, or you need to apply for a FinCEN ID. And so, guys, this is where if you're forming a lot of entities, or involved in the formation of a lot of entities, and your paralegal is too, then I'd recommend getting that FinCEN identification number. And the FinCEN ID, essentially, there's going to be an application. The draft form's out; it's not finalized yet, where you disclose all this information one time. FinCEN issues you an ID number, and then for any subsequent disclosures, you've just got to put your FinCEN ID number on there, not all of this stuff every time. So if you're going to be involved in all of this, FinCEN ID, recommend you get it once it becomes available to get. I have a question: is the applicant is the organizer named in the document the person directing the filing, or both? Is the organizer, so if the paralegal files the articles of incorporation, but we actually got the client to sign as organizer and just filed on their behalf, who are we going to need to list as applicants there? I would still say that the way the examples in the final regs read, that's good. The paralegal is going to be an applicant, and the attorney is going to be the attorney who is in charge of the process and mostly dealing with the client is going to be an applicant. And the client itself, or the officer of the client itself, may not be an applicant, but they may be a beneficial owner also anyway later. But the way the examples read, I really think they're trying to figure out, they really want the attorneys to report themselves as applicants. Again, that gatekeeper piece I was talking about. They don't want attorneys to be able to hide behind getting other people to sign stuff or other people to file it from being applicants, is the way the regs are reading right now. We go to the next slide. And so the reporting company itself also has to report similar information. So full legal name of the reporting company, alternative or trade names, when they're making this beneficial ownership information filing, principal place of address. And so again, if you're a reporting company and you think you may be doing this a lot, or you're going to have other instances where you may need to file this, the reporting companies can also get a FinCEN identification number as well. But if not, then you're going to have to use your EIN or your foreign tax ID number to report. Move on to the next one, Matt. Okay. So the important stuff, the stuff everybody wants to know, are compliance deadlines for reporting FinCEN. So as of today, existing companies that are formed before the effective date, so formed before 1/1/2024, you have to comply within 1 year after the effective date. So on or before 1/1/2025. So pre-existing companies essentially have a little over a year now to comply, to make, to figure out if they're a reporting company, figure out who their beneficial owners are, don't need to worry about the applicants, and file that first form before 1/1/2025. Formed on or after 1/1/2024, the final regulations in their current state say within 30 days of formation or meeting the definition of a reporting company. The proposed regs that I mentioned at the beginning, there's a set of proposed regs out that just make one amendment to the final regs and essentially say that entities formed between 1/1/2024 and 12/31/2024. So the first year that this is effective, entities that are formed the first year this is effective are going to get 90 days to file the reports instead of 30 days. So an extra 60 days. The funny part about all this is the statute actually says, companies will have a maximum of 90 days to file. And FinCEN, instead of just going with the 90 days, articulated in the statute, went with a shorter time frame in the proposed regs and in the final regs. And people have complained about it so much that they at least, conceded a little bit there to go back to 90 days for the first year. If the beneficial ownership of the reporting company changes, and I guess this is another headache for some of your community association folks, if that board changes every year, you might have to file an updated report every year within 30 days of change, which is why some of those policies may be important in terms of addressing that. So if the beneficial ownership changes, you need to file an updated report with FinCEN within 30 days of the change. If you realize there's an error in the initial report that you filed or whatever report that you filed, you need to change the report within 30 days of discovery of the inaccuracy. Now there's a statutory safe harbor that says if you do that within 90 days, then there's no penalties. But the regs went with 30, even though there's a statutory safe harbor for 90. So if you do it within 90 days, there's still not going to be any penalties. And exempt subsidiaries that become reporting companies. So if you're an exempt subsidiary, because you're just wholly owned by a large operating company and you get spun off to your own independent company or new ownership that's not a exempt entity, then you need, in your reporting company now, you've got 30 days after you no longer meet any such exemption to file your report. Move on to the next one. Okay, so here are the violations. $500 per day that the violation continues. There is no max or cap on this penalty right now in the statute or the regs. So $500 per day until the violation is done. If FinCEN deems your willful reporting violation to be criminal, you can be a fine of up to $10,000 or 2 years imprisonment or both. Senior officers of an entity that fail to do this or prevent the entity from filing can be held accountable civilly or criminally as well. Same thing, similar penalties for unauthorized disclosure or use by some of the government agencies or regulators that are going to have access to it. Similar penalties, bigger criminal penalties because they're in a position of responsibility. But there's the penalties and violations. Matt, can we move on to the next one? Because here's a statutory safe harbor that the regs did not modify or enhance. If you're not subject to penalties, if an inaccurate report is voluntarily and promptly corrected within 90 days or less. you know, this safe harbor is not applicable if the discoveries are made after 90 days. So, if you make the discovery on day 91 and report it on day 92, file the report on day 92, you're outside of the safe harbor. But you may still be within the regulatory safe harbor, because regulatory safe harbor is 30 days after discovery. So two, issues, differences between the regs and the statute there that have not been harmonized and probably will not be harmonized. There is a reasonable cause exception. I am hoping that FinCEN, like the IRS does with new reporting requirements, issues some sort of transitionary penalty relief that, like, we're just not going to apply the penalties in the first year if you can show any sort of reasonable cause, but we will see. Matt, can we move on to the next one? All right. So, talked about community associations, talked about SPEs a little bit, but, again, with the broad definition of reporting company, I think a lot of your clients and a lot of just real estate industry businesses are going to be impacted by the Corporate Transparency Act. There could be a significant, continual reporting obligation for a lot of entities. And then, in some of these real estate investment entities, the passive owners might not even know each other. How are you going to collect all this information in 30 days after formation to get this right? Some of these funds ownership may change frequently, and if big enough pieces of it change, you might be filing multiple updated reports every year. It could be a pain, a really big pain. So I think some people will start to look to structuring arrangements to avoid or minimize CTA reporting. Now, the report itself, it's not going to take a lot of time to fill out, right? But it's doing the analysis and then gathering the requisite information that's going to take the time, and obviously dredge up some sensitivities among a lot of folks. Are you going to try to use CTA exempt entities as blocker entities? Is that going to create some issues with how the day-to-day operations work? Probably. Are we going to see an uptick in the use of general partnerships and just joint ventures with a joint venture agreement? Maybe. I don't know. I don't think the financial institutions or lenders are going to be on board with this, but you guys might feel differently. It's going to be interesting to see. Are we going to start having provisions in operating agreements that the members are going to comply with the beneficial ownership reporting requirements of the Corporate Transparency Act to provide all information necessary? I think we're probably starting to see some of that. So, are we going to want better privacy policies in operating agreements and other things like that for funds and sponsors, just to make sure that whoever you got to give this information to keeps it safe? Matt, can we move on to the next one? I think from the financial institution perspective, they're going to like this because it's probably going to make their job easier on the customer due diligence and know your client rules. I think financial institutions and most major lenders are going to, make you consent to give them access to the database, to the BOSS database, to pull and verify your information, or they're not going to lend you the money. There's going to be some, provision in there, I guess, in the miscellaneous provisions, saying that guarantor and borrower, consent to, comply with the CTA compliance requirements, and to give, give lender the ability to access, pull their information as needed to verify. All that stuff's going to be in there. I'm sure some of you guys are seeing it already, maybe in some of your deals, particularly with some of the larger financial institutions. In terms of the financial institutions, at a minimum, they're going to be able to request, after they get the consent of the beneficial owners, that information of the entity, request, a transcript of that information from FinCEN. And once the regs come out that kind of harmonize the Corporate Transparency Act with the customer due diligence regs, I think that'll become a little clearer. Looks like there's some confusion about whether this is an annual report or just an initial report. Okay, it is just an initial report unless unless another thing triggers a change or need to update the report. So it is not a continual annual filing obligation. It's an initial reporting obligation, and it becomes and the only part of it that's continuing is if ownership changes, if there was a mistake on the original filing. If it needs to be updated for some reason, then it triggers an additional filing within usually 30 days. So, that's, just hope I cleared up that confusion in the chat. Initial filing doesn't need to be filed again unless a change in ownership or or something else triggers a need to update the form. Can we move on to the next one? All right, law firms. I see some chatter about this in the chat already. Again, I think you should pretty much assume that lawyers and the paralegals or assistants who actually file the formation documents are going to be applicants if they form a reporting company. And to go along with that, I'd recommend go ahead and getting those FinCEN IDs if you do this on a regular basis. Absent that, you're gonna have to disclose your social security number, your driver's license number on the form. Again, I guess we got some major client compliance concerns, right? We tell them about all this, tell them they need to do it within 30 days or maybe 90 days in year one. And what if they don't give us the information? Or what if they say they're going to do it and they don't file it? Or what if we know the information is incomplete or inaccurate? I think these are problems we're going to be dealing with for quite some time in this area. How does your firm want to insulate the attorneys in the firm from liability? Do we get some sort of FERP to S certificate for the Corporate Transparency Act from the clients now? Is there some form like that that's going to be generated? Do you want to make it very clear in your engagement letter that, hey, we're going to inform you of these obligations, but we're not going to file, or like, hey, we're going to charge extra if we're going to file these? Are you going to cover, Corporate Transparency Act compliance in the engagement letter when you're forming entities? Probably so. You're going to want more detailed client intake procedures. Possibly. We have our own know your client questionnaires as law firms. It's things we've been bouncing around here for sure. I'm guessing some of your firms have been doing as well. Matt, go to the next one. I know we're probably past, looks like I'm a couple minutes past my time, but again, operating agreements, I think, are going to start. You're going to want to start addressing this in some of the operating agreements, particularly when you know what the ownership is and they're going to be a reporting company, at least initially. And when you need to, if you're being engaged to help with this and determining substantial control, really need to consider what governing docs are going to be reviewed, or how are you going to draft those to make that clear? How deep is the inquiry? Again, it's all very very crucial. Privacy concerns, security of information. Are you going to want to handle this information? Or are you going to want to push the actual submission of the form down to the client? Will people who are preparing these disclosure forms as FinCEN be able to rely on, certificates or something from the client, similar to FERP certificates? I think all these are questions. Yeah. Okay, so the database itself, proposed regs came out in December 2022. First of all, FinCEN is going to keep your beneficial interest reporting information for at least 5 years after the date on which the company terminates. So, if you liquidate and terminate in this year, they're keeping that till 2028. Again, the act provides that the information is going to be confidential and not disclosed except provided in the act. It's essentially what that means is It's going to be a Federal Information Security Management Act, FISMA level security, FISMA high. So highly sensitive but not classified information is kind of how they're treating the information. The database is supposed to comply with FISMA at a FISMA high level. Some of our data privacy guys may know what that means. I have no idea what that actually means. So I can't dig too deep there for you guys on that one. But in terms of how are different agencies going to be able to access it, authorized users from federal agencies, so FBI, DOJ, IRS, other agencies in Treasury, beyond FinCEN and IRS, are going to have like a login to the system, going to be able to run queries, pull information, and just state the reason why they're pulling this information. So it's really going to be like just a pure database for a lot of federal agencies to query and search, as long as they have a justifiable reason for it. There's going to be audits of each agency that has access to this. I don't know what the time frame is, but there's going to be audits to make sure they're not, abusing it or, unauthorized use, etc. In terms of kind of state law enforcement activities, they're going to have to get a court of competent jurisdiction to grant them permission to request access to the information from FinCEN. And a court of competent jurisdiction is any court with jurisdiction over the criminal or civil investigation for which the state agency is requesting the beneficial interest information. So it could be part of civil investigation, it could be part of a criminal investigation, but they're going to need the permission of the court in that jurisdiction to grant them access to make this request of FinCEN. And foreign law enforcement is going to have to utilize either federal or state local law enforcement to get access to it. And there's going to need to be a national security or intelligence activity reason to access the database. Again, these regs still need to be finalized. I'm sure there's going to be some tweaks. And again, the database is supposed to be live on 1/1/24. FinCEN's apparently testing and beta testing it, but that's about all they've said on it so far. Next slide.
David, don't want to interrupt you,
Yeah.
but we are about 10 minutes over,
Okay.
and I know some folks are having to kind of duck out. I
Sure.
do want to give Sarah and Town an opportunity. So is there a slide or two that you want to kind of summarize for us? Or, I mean, I can tell you.
Sure. I think I'm pretty much done. The only thing I will say is
great information.
Yeah. The only thing I will say is the form.
Oh, I think we might have lost David.
No,
My
I'm back.
interruption might have kicked him off. Okay.
No, I'm back. It's just the conformity between the customer due diligence rules and the Corporate Transparency Act are forthcoming. That's pretty much it.
Okay. Well, David, thank you so much. There's David's name and email address and telephone number. I know many of you have questions that were written in the chat box. David, don't want to volunteer you or but I'm sure you'd be glad to answer questions if anyone has any questions, which there were many. I can tell you unequivocally that this is the first time that I feel like I truly understand now the Corporate Transparency Act. This has been a great presentation and great information, and we really appreciate you being here, David, so thank you. Again, questions, comments, as I said, any feedback on this program, please shoot me an email. Next, Return to the Vault, November 8th. For those of you who were with us last month, if you weren't here, we covered Odyssey, the VCAP transition to Odyssey. This month was Corporate Transparency Act. Now I'm concerned that we need to start making sure that everybody's mental health and blood pressure are okay after these programs, because both of these programs the past 2 months have been pretty scary. But November 8th, legislative update, hopefully that will be less worrisome for everybody, and we'll look forward to seeing Nancy Ferguson with us that day. And with that, I'd like to turn things over to Sarah Boschert, Senior Vice President and Private Banking Officer with Town Bank.
Well, thanks so much, Matt, and thanks, David, for your presentation. Just wanted to share briefly a little bit about Town Bank, and then I'll go ahead and announce the winners of the gift card since we're running a little bit over. But so Town Bank has a history of focusing on and working with the legal community dating back to 1999. Some of you may recall that we were originally Paragon Bank here in the Raleigh market. So I had a predecessor here, Pat O'Quinn, who served in this position for 15 years, and then I took over for her 6.5 years ago. So we really understand your day-to-day needs because that is really my focus. I'm a private banker that specializes in banking law firms. For anyone who is practices residential or commercial real estate, my team and I have a good understanding of, IOLTA and the trust accounting laws. So we bank over 100 law firms across the state in all practice areas. Prior to me coming to the bank, I spent 30 years in title insurance. So in various roles. So within some of those roles, I handled commercial disbursement. So for anyone who is doing any transactional work, have a good frame of reference of understanding the pressures that you're dealing with there. We have a team approach here. So I have 2 people who help support me and my clients. We also have a legal partner program that really focuses on you all and your needs. So I'll just highlight a couple things real quickly from that program. There are other benefits, but it does include complimentary incoming and outgoing wires, and also complimentary stop payments and check positive pay as a check fraud prevention measure, because I'm sure you're all aware we've seen a lot of that in recent years. And then finally, we're really a true community bank. So unlike, some of the failed banks we had earlier this year, I mean, we really are kind of a Main Street bank. We know our clients and they know us. And perhaps most importantly, we are very philanthropic in the community. So since we were acquired by Town Bank in 2017, I think the rough number is we've donated to various organizations over $12 million in this market. And I think we have a foundation, I believe about $100 million since Town Bank's inception out of that foundation. So those are the highlights about Town Bank. I can drop my information into the chat if anybody wants to reach out or has any further questions, but I'm going to go ahead and announce the winners of the gift cards. So we have Jennifer Leonard, Nate Cook, Natasha Gagger, Zach Hines, Steve Reinhard, Stephanie Crosby, Paula Kohut, Paige Please, Nick Livingwood, and Mark Wampler. So congratulations, everybody. And I will drop my info into the chat. So thank you so much.
Well, thank you, Sarah. Thank you to Town Bank. Thank you again to David McCallum, and thank you all for being here with us today. Again, this was a extremely beneficial and helpful, part of the pun, beneficial, extremely helpful presentation and program. And we look forward to seeing you all back here with us in November. Thanks, everybody.
Thanks.